What's going on, y'all? Attorney Tom here. In today's video, I'm going to be going over the FTX class action lawsuit that was just filed against SBF and the celebrity endorsers of FTX, such as Tom Brady, Giselle, David Ortiz, Larry David, Steph Curry, and many other celebrities. I'm going to be going over the facts of this lawsuit and giving you my opinion on whether or not I think this is a valid case. And if it is a valid case, who is it a valid case against? Because there are lots of people, lots of defendants added into this complaint, and some of them have different levels of involvement. Now, before we begin, I'm going to play a 2-minute segment from my friend CopyZilla. He gives a good recap of what has happened up to this point.
FTX told users that their digital assets belong to them and wouldn't be traded. It's explicitly laid out in their terms of service. Quote, you control the digital assets in your account. FTX Trading does not represent or treat digital assets in users' accounts as belonging to FTX Trading. And title to your digital assets shall at all times remain with you. But turns out this wasn't the case at all, because according to an Alameda research employee who came to me anonymously, apparently they had more access to FTX than previously disclosed. In fact, not only did they have access to FTX's back end, they managed withdrawals for FTX and had a giant line of credit that they could draw on, which seems like partially may have been users' funds, something that no separate entity would normally have. Now, bear in mind, that is coming from one employee, but it's backed up by another source, the Wall Street Journal, who reported that FTX extended loans to Alameda using money that customers had deposited on the exchange for trading purposes, which they just said they wouldn't do. Quote, it was a decision that Mr. Bankman-Fried described as a poor judgment call. But I would disagree with Mr. Sam Bankman-Fried. I would not describe that as a poor judgment call. A poor judgment call is showing up to a Zoom meeting looking like this. When you take clients' funds and do exactly what you told them you would not do with them, that's theft, and that is fraud.
And while there are at least a dozen other shady activities that are revolving around this situation, I picked this particular clip because you get the gist of it. People were depositing their funds in crypto into FTX on the understanding that it was their crypto and there was no inherent risk of them having their crypto on the platform, but that clearly wasn't the case because FTX on the back end was using those funds to trade with Alameda Research. As the result of Alameda's terrible trading, they don't have enough funds to back everybody's assets up. So when the bank run happened, there were no funds for anybody. That's like the equivalent of you having your money in a bank, and then when it's time to get your money out of the bank says, we actually traded it all away and lost it, and you're going to be the one who has to pay the price. And that leads us to where we are right now, which is the lawsuit against SBF and the celebrity endorsers of SBF's company, FTX. Now, before we continue on with the analysis of this lawsuit, I want to separate the defendants in this case into two distinct categories. SBF and his internal FTX team, or the executives of FTX, and the celebrity endorsers, because I think they have different exposure. Now, this lawsuit has 3 main counts in it. Count 1 is a violation of the Florida Securities and Investor Protection Act, section 517.07. The second count is a violation of the Florida Deceptive and Unfair Trade Practices Act. And the third cause of action is civil conspiracy. Okay, so let's just start with count 1. The alleged violation of the Florida Securities and Investor Protection Act. It says section 517.211 and extends liability to any director, officer, partner, or agent of or for the seller if the director, officer, partner, or agent has personally participated or aided in the making of the sale, is jointly and severally liable to the purchaser in the action for rescission if the purchaser still owns the security, or for damages if the purchaser has sold the security. Now, the key question to the validity of this particular claim is whether or not cryptocurrency or the yield-bearing accounts that FTX was offering are considered securities. Because if they're not securities, well, then there's no claims, because this is a claim under the Florida Securities and Investor Protection Act. So if there's no security, there's no protection for securities fraud, because It's not a security. And quite frankly, the answer is it depends. Cryptocurrency litigation is new. We are on the forefront of it. Some courts have held that cryptocurrencies are securities, especially in the earlier ICO litigations that we saw a few years ago. Now, some courts have come out and said that cryptocurrencies aren't securities. So I can't really give you a good indication on whether or not I think a court is going to find this to be a security, because at this point, it's basically a toss-up with the way case law is going. Now, what I can say is if the court does find that this is a security, these celebrities could be in some trouble. Yeah, so let me just give you an example. This is Tom Brady here in an FTX commercial, and you can see if this is found to be a security, how there could be some liability for him given the law.
Are you sure? Not a trade. I'm trading crypto. FTX is the safest and easiest way to buy and sell crypto. It's the best way to get in the game.
He's trading crypto.
Oh.
The safest and easiest way to trade your crypto, while simultaneously FTX was also trading your crypto without your knowledge. So to wrap up count one, if this is not a security, well, no case for any party because it's not a security. If it is a security, potential liability against everyone. Now, with respect to the second count, the alleged violations under the Florida Deceptive and Unfair Trade Practices Act, this is where the division becomes really important. As stated in the lawsuit, the stated purpose of the FDUTPA is to protect the consuming public from those who engage in unfair methods of competition or unconscionable, deceptive, or unfair acts or practices in the conduct of any trade or commerce. Now, I don't think we even need to go into an in-depth analysis on the liability of SBF and his executive team. Anybody associated with FTX, Alameda Research, all of those entities, I'm going to go out on the record and I'm going to say they're probably liable for unfair and deceptive trade practices. Now, with respect to the celebrity endorsers, I'm not so sure about that. And that's because the plaintiffs are going to essentially have to prove that these celebrities knew that FTX was a fraud, yet still decided to push it anyway. Hey, Tom Brady, it's SBF. Hey, dude, what's going on? Hey, so my cryptocurrency company, FTX, is a total fraud. We are stealing people's money left and right, but we're going to pay you a whole bunch of money to promote it. Are you in? So you're telling me it's a fraud, but you're going to pay me a whole bunch of money? Hell yeah, I'm in. And obviously that was an over-exaggeration, but you're going to need some sort of evidence like that in order to prevail. Now, what a lot of y'all are probably thinking is, hey, Tom, they don't actually had to have known it was a fraud because the statute says the word unconscionable, which doesn't require actual knowledge. Well, that standard is so absurdly high, and given the perceived legitimacy of FTX, the hundreds of millions of dollars they spend in advertising across various different industries and multiple different celebrities, I think you could easily make the argument that while maybe negligent in promoting FTX, it was not unconscionable for these individual celebrities to promote FTX. At least that's my opinion. So to conclude on count two, absolutely a case against SBF and his executive team, everybody involved in the internal workings of FTX. With respect to the celebrity endorsers, unless there's some smoking gun evidence that they knew or showed extreme unconscionability that they should have known that FTX was a fraud, I think it's a weak claim at best. And quite frankly, moving on to count three, it is very similar to the analysis in count two. There's strong evidence to support a conspiracy. You don't just lose billions and billions and billions of dollars of trading without some form of conspiracy. For instance, the conspiracy of Alameda to take clients' funds that weren't meant to be traded and use them for their terrible trading. They had to conspire with multiple entities to make that happen. Now, with respect to the celebrities, I think it's going to be hard-pressed to find a conspiracy. Hey, Big Poppy, it's Tom Brady. What's up? Hey, what's up, Tom Brady? Okay, so listen, I just talked to my friend SBF. He has a huge crypto scam going on. If we get all the celebrities together and we promote it, we can make a ton of money. But it's a scam, but we're still going to promote it. You cool with that? Yeah, I'm cool with that. Again, that's a huge over-exaggeration, but you get the point. So to conclude, if the court finds that what FTX was offering was in fact a security, well, all the celebrities could in fact have liability, but that's a toss-up. Courts are split on this issue. There's no definitive declaration at this moment. But if it is a security, well, the law provides a remedy against those who promoted said security, jointly and severally liable for the damages that it caused. But if it's not a security, the other counts to me seem pretty weak, at least against the celebrities. I think the SBF team or the FTX team run by SBF are probably liable, at least from the evidence that I've seen, but the case against the celebrity seems pretty weak if this thing is not considered a security. All right, y'all, talk to you later. Bye.
He's a catastrophic injury attorney who accidentally became a YouTuber. Attorney Tom.